no treaty, no law, no land. In 1881, the Kingdom of Hawaii was recognized as an advanced, neutral, self-governing sovereign nation with currency based on a gold standard under the Universal Postal Union. Hawaii was a world diplomatic leader with 56 diplomatic councils living abroad. The Kingdom of Hawaii has 23 international treaties and is a founding member of the Universal Postal Union. By 1887, the kingdom had 46 international treaties and 90 embassies. In 1893, the Kingdom of Hawaii was invaded by the USA. Deceived by a group of wealthy American businessmen, U.S. Marines deployed overwhelming firepower and took control of Hawaiian land, assets, and government at gunpoint. This group usurped control as the provisional government. They violated 5 treaty accords and were labeled traitors. Despite Queen Liliuokalani's protests, the petition of 38,000 kingdom citizens, and President Grover Cleveland's attempt to right the violation of both international and constitutional law, the traitors were never forced to relinquish control and restore Queen Liliuokalani to the throne of the Kingdom of Hawaii. No treaty of cession or other document allowing legal transfer of Hawaiian land and assets was ever created. Annexation was vetoed on its unconstitutionality. Congress had no constitutional power to acquire Hawaii by joint resolution, but proceeded nonetheless. Congress has no authority to enact legislation in Hawaii and never has.
What we're dealing with here, in practical terms, is 1.8 million acres in ceded land, the former Crown lands, over which the state of Hawaii now has trust responsibility, and about 200,000 acres of Hawaiian homelands, which Mr. Kane directly administers on behalf of the people of the state today. And the reason that you get these questions now, in all honesty, Doc and everybody else, is that when the 1.8 million acres were seen as essentially worthless, which is the reason that these particular lands, because you could have said at the time that the entire state was Crown lands because it was a kingdom. When we put Western ideas of property and ownership into the equation, well, then it became somebody's land. They owned it. And so the 1.8 million acres essentially were seen as something that the merchant bankers didn't need. So the 1.8 million acres wasn't seen as worth anything. The 200,000 acres that Mr. Kane administers right now again we're seen as, well, we'll just give that to the Hawaiians. Nobody wants it. There's no water. There's no infrastructure. There's no anything. It's not useful to anybody who wants to make money out of it, so we'll give that to the native Hawaiians. Now, come to 2010. How would you like to have, Doc, 1.8 million acres of land in Hawaii today? How would you like to have 200,000 acres in additional land reserved for Hawaiians by congressional act? When we come down to it, when you get right down to the nitty-gritties of all of this, this has nothing to do with the Constitution. This has nothing to do with race. This has to do with assets, land and money. And when that 1.8 million acres wasn't yielding any money, when that 200,000 acres was out there and it didn't have any value to them, let me tell you, now you got 2 million acres of land in Hawaii. You got hundreds of millions of dollars in funds that are under the care of the Office of Hawaiian Affairs right now, which will go to this new entity, and you've got an income stream in the tens of millions of dollars coming from the lease arrangements on either the ceded lands or the Hawaiian homelands, so that you can build houses, you can put infrastructure in. Now, everybody's interested that they're not discriminated against. And what they mean is how can they get in on owning, controlling, maneuvering, and manipulating that 2 million acres of land, the hundreds of millions of dollars, and the tens of millions of dollars of income stream. I rest my case.
Good afternoon. Thank you very much for allowing me to address you all this afternoon. My name is Kilikina Kekomano. I'm a Kanaka Maoli. My 11th great-grandmother comes from Big Island, Napopo, 1725. I represent the Aloha Kikyo Ainas of Hawaii. I live in Waianae. My purpose here is to publicly renounce this Act 55. It is emotional for a Kanaka Maoli person when we lost our country January 17th, 1893, and then we were illegally occupied permanently from August 12th, 1898. In doing so, my country, beloved country of Hawaii, was never conquered, was never acquired, and there was never a treaty. In understanding the ramifications of that, the April 30th, 1900 Organic Act, which is all your laws in this state of Hawaii, has the jurisdiction of a territory, because it is a territory. The territory of the Act of April 30th, 1900's jurisdiction is American Samoa, Northern Marianas, the Virgin Islands, Puerto Rico, and District of Columbia. My point is I can't understand what laws you're executing in your jurisdiction to commit malicious, premeditated malfeasance on the Kanaka Maoli people, on the people of this land, and on my ancestors that have never relinquished one title under the Royal Patent Lands of 1855 under King Kamehameha's probate will. Those 1,800,000 acres are in perpetuity. And if I need to define that for you, it can never be sold, taxed, liened, or mortgaged. In effect, your laws are totally not in effect. You have no jurisdiction, no warrant of law, and no warrant of treaty. You have the United States of America needed a treaty for its major three accusations, which was from Napoleon in 1803, the Louisiana Purchase, the American-Mexican War, the Treaty of Guadalupe-Hidalgo in 1848, 15 million, and don't forget Russia with love, 7.2 million in 1876. My case in point, there is no treaty that allows any law other than kingdom law. May I remind you, during World War II, when the United States occupied Japan and Germany, common law has been exercised in every country that America has occupied, with the exception of the Kingdom of Hawaii. So our laws are not gone. 1-1 under Williamson, Richardson. That was for excess. We have more than excess. We have all the laws. My family and heirs, with our DNA, we are the law. We own those patents. And now you're going to develop land that you have no warrant of deed or title. You don't even have a treaty to exercise your laws. I am grossly confused. How can you pursue this malicious, premeditated malfeasance on my people without warrant of deed or title? That was all rescinded January 17th, 1893. There was no Bureau of Conveyance. There was no notary. And then you had 50 U.S. American businessmen and sugar plantation owners, with the aid of the USS Boston of 157 men with 10 officers, that came in on a man of war, broke international law, occupied our islands, raped the Queen of her land, her resources, her gold, and 46 international neutral treaties. Now show me, I don't understand what law you're using. There is no law in this state. It's a corporation under an act of the District of Columbia, which is a territory. Thank you.
Mahalo nui for watching. Since 1893, Kanaka Maoli people have been robbed of their land, assets, resources, education, rights, and privileges. International law has been steadily violated. Enacting constitutional law in Hawaii is unconstitutional. No treaty, no law, no land. No treaty, no law, no land. Prior to seizure of the land by the U.S. corporation, Western ideas of property and ownership had evolved in Hawaii. Assets that Hawaiians needed to thrive were made available to all kingdom citizens. The bequeathal by the 19th century Hawaiian monarchs is still binding, and although violated, it is still the law. No treaty, no law, no land. No treaty, no law, no land, no land.